5 seconds to go. Start. It was next submitted that Section 7 of the Act speaks of acceptance or obtainment or an agreement to accept or an attempt to obtain. Further, the expression acceptance must be differentiated from the expression receipt as they convey different meanings in the context of Section 7 of the Act. That Section 7 of the Act does not speak of receipt but only of acceptance. In order to convert receipt into acceptance, it should be proved that a demand is made from the bribe giver. In other words, the bribe giver should have offered the gratification while demanding a favor from the public servant. Therefore, the mere receipt of any property or valuable security would not amount to acceptance unless the bribe giver had made an offer demanding favor from the public servant. This fact in issue should be proved by direct evidence. However, if the bribe giver or the complainant dies or turns hostile and the fact cannot be proved by direct evidence, then it could be proved by the evidence of another witness who has direct knowledge of the said fact or even by circumstantial evidence. In the event the fact of acceptance is proved, Section 20 would apply and a presumption has to be raised that the acceptance was the reward of an act. Further, no presumption of acceptance can be raised under Section 114 of the Evidence Act in the absence of foundational facts being proved. It was submitted by Shri Nagamuttu, Learned Senior Counsel, that once acceptance or obtainment or agreement to accept or attempt to obtain is proved, then the presumption under Section 20 vis-a-vis motive or reward could be raised in the context of Section 7 of the Act. But acceptance or obtainment or an agreement to accept or an attempt to obtain cannot be established by means of a presumption in the absence of foundational facts. The reason why Section 20 raises a legal presumption is in order to prove mens rea of the accused, namely, that the public servant knew that he had received illegal gratification as a motive or reward. Since this fact is difficult to be proved by direct oral evidence or documentary evidence, the Parliament in its wisdom has incorporated Section 20 of the Act with a mandate to the court to presume the illegal gratification as only a motive or reward. Of course, such legal presumption is also rebuttable. Coming to the actual question raised before the Constitution Bench, it was submitted by the Learned Senior Counsel Sri Nagamuttu that the Act of Obtainment contains two facets, namely prior demand and receipt of illegal gratification by the public servant, and both these facts should be proved beyond reasonable doubt. The fact of demand could be proved by oral evidence. However, in the absence of complainant's evidence to prove obtainment or an attempt to obtain, the presumption under Section 20 cannot arise. Further, if such obtainment or attempt was witnessed by some other witness, then that witness can prove the said fact even in the absence of the bribe giver being available to be let in as evidence. On the other hand, in the case of acceptance or agreement to accept the gratification, the offer should have been made by the de facto complainant and the accused public servant should have accepted the offer. In this case, there is no prior demand by the public servant. Therefore, even if there is proof through other evidence that the public servant received some property from the de facto complainant, that will not automatically go to prove acceptance in terms of Section 7 of the Act. In other words, mere receipt of a property by a public servant does not amount to either acceptance or obtainment. To convert the receipt to acceptance in terms of Section 7 of the Act, it should be proved that an offer preceded the receipt, and in the case of obtainment, the receipt should be preceded by a demand by the public servant. With reference to M. Narsinga Rao, it was contended that this court has not dealt with the difference between Section 7 and Section 13(1)(d) of the Act, and with regard to the difference between acceptance and obtainment, and also the non-applicability of the presumption under section 20 in a case which falls under section 13(1)(d) of the Act. According to learned senior counsel Shri Nagamuttu, M. Narsinga Rao does not lay down any proposition of law. Further, with reference to M. Narsinga Rao, it was submitted that demand being a sine qua non for subsequent receipt of illegal gratification could be proved by circumstantial evidence subject to the principle that the change of proved circumstances should unerringly point towards the guilt of the accused, and there should not be any other hypothesis that could apply. It was contended that in the absence of the bribe giver, the proof of demand could be presumed from circumstances. With reference to P. Satyanarayana Murthy, learned senior counsel contended that only a presumption of fact of conduct can be raised as per section 4 of the Evidence Act, that in the said case the complainant turned hostile and there was no other direct evidence to prove the demand but that the tainted currency notes were supplied. Stop.